So nice to have so many of you here this week. Welcome to the third in our series of grant classes. We're so happy to have, like I said, all of you here tonight. We are with TWU Center for Women Entrepreneurs. I am the Small Business Advisor, Tracy Irby. Some of the things that we do is provide business advising, funding. We have many of our micro grant winners in here, networking, and training. So we do have a series of classes that we do in the mornings as well. Networking next Tuesday is our Rise Women Breakfast. It's here at 7:30 a.m. Goes to 9. You get a free breakfast. Our speaker is going to be Randy Skinner. She'll be talking about social media and some other things. She's a great speaker, so you all are welcome to attend any of those if you'd like. I am pleased to introduce Christopher Henry. He will introduce himself.
That should work. All right, well, my name's Chris Henry. I'm an attorney here in town. I was born and raised here in Denton. Went to Denton High School, went away for a while, got an education, just couldn't stay away, came back, and I've been practicing law here in Denton since 2009. I'm now a partner at the oldest continuously running law firm in Denton, Minor and Jester, and we're here to talk about business entities. I don't have a PowerPoint or anything like that, so if you want to take notes, take notes. I find a lot of times people don't pay attention to me, they're reading what's on the slides. And what I have to share with you guys today and the information I'm going to impart upon you today is more so from a conceptual idea and why you need an entity, what they're going to do for you, what they can do for you, what they can't do for you. So if you do want to actually get an entity created, I would suggest you consult with either legal counsel or at least tax counsel. They do have these legal Zoom and things of that nature where you can go online and get your LLC created for $100 or something like that. Does that work? Yes, it works. Is it the best idea? Probably not, because just as each one of you is an individual and your business is different from the person sitting next to you, so should your entity docs be different than the person sitting next to you. So that's kind of where I'm going to come from, give you general concepts. Let's start with, I actually had some questions earlier today from folks in the room about a DBA and how that's kind of different than an entity or an LLC. A DBA is just you. DBA stands for doing business as, and that's what you're doing. If you file a DBA, it's just you individually doing business as a different name. There's no difference between you and the DBA. It's really what I consider a DBA is a marketing thing, a marketing idea. It's not your name anymore. You're doing business as something else. But still, from a legal and liability standpoint, it's still you. And that's where the entity formation comes in. The main purpose, there's probably 2 or 3 main purposes of creating an entity. The number one from where I sit is liability protection. If you create an entity, an LLC, a corporation, a partnership, anything like that, from a legal standpoint, it is recognized under the laws of every state as a totally separate person, legal person. So if you enter into a contract or you've got customers or you're interacting with anyone else in this world as an entity, that's one thing. It's got liabilities. It's got contractual obligations. You may own it, but it in and of itself is a separate person from you, which is great when you get sued. Because, what's that? Because you as a person, you have a car, you have a house, you have all the stuff in your house, you have all of these things, you have your own bank account. Well, if your entity gets sued or your entity has some sort of problem, your personal stuff is totally separate, as long as you have kept all of your corporate docs clean. Okay? And that's one of the reasons why you need to stay in touch, even after you've created this entity, if you choose to do so. You need to stay in touch with your legal counsel or with your tax person about continual maintenance of your entity. Because if you create it one day and then you go on about your business 10 years later, oh yeah, I have this LLC and I think I'm doing business under my LLC. Well, if you haven't been maintaining it and you haven't been actually using it, then if somebody decides they have a problem with you, they may be able to get to you individually. And that's what we want to prohibit, is anybody coming after you individually. That's the whole purpose of an entity. Also, a little beyond the scope of what I can talk about is consult your tax professional. A lot of the reasons that people also create entities are for tax advantages. There are fancy things you can do with an LLC or a corporation that you can't do by yourself. They have, yes, you can write off business expenses, but there are fancy stuff that CPAs can do that I can't speak to. So that's another reason why you might want to incorporate or form an LLC or a partnership. So we've got liability protection, we've got tax advantages, also organizational structure. If you're an individual and you're doing your own thing, you're the only owner, you're the only operator, it's a one-man show, one-woman show, the entity from an organizational standpoint probably won't give you a whole lot of advantages. But if you ever want to bring in partners, or there's two of you right now, and y'all want to get together, two people can't do business as a DBA, because that's a one-person thing. You're doing business as something. So if you want to organize with someone else, it would be highly, highly recommended to create some sort of entity which creates, number one, an organizational structure. Number two, it creates rules. Rules. The best way to break up a friendship is to go into business together. Absolutely the best way. I see it all the time. Best way to break up a marriage, go into business together. I see it all the time. But as long as everybody is involved in the creation of the rules, the entity documents, what's going on, everybody understands the ground rules, and if something does go sideways, if it's written in there and everybody had a hand in what's written, then it's usually a lot easier to figure out. So that's also why your entity docs need to look different than yours, because everybody's got a different situation. So organizational structure, tax advantages, and liability protection. Those are the three biggest reasons why you would want to, I'm going to say, incorporate or create an entity. Now, I keep making reference to corporations, LLCs, partnerships. There are different forms of entities. They are treated differently under the tax code. I don't know how. I just understand that they are. So I would suggest that you consult your tax professional with regard to that on choice of entity. But from where I sit, and here's, I'm actually going to go back to my notes here. Most people, when they think about a business, you think about a corporation. Because up until about 30, 40 years ago, that was really the only, that and a partnership were the only two types of entities that really existed until LLCs became all the rage. But corporations, generally, you've got layers of management, which again, as the business gets bigger, helps out. You've got layers of management. You've got your shareholders, which are your owners of the company. If you own shares in a company, you own the company, and ultimately, at the end of the day, you have the say-so as to what happens. Then a step up from the shareholders, you've got your board of directors. And everybody has heard the board of directors of all these companies. That's really the management level of a corporation, is your board of directors. And most small businesses, the shareholders and the board of directors are the same folks. As your business gets larger, That may not be the case because you may want to get somebody in who really knows what they're doing. They're going to sit on your board, and you may just be a shareholder. Then a step beyond that is after you've got your board of directors will appoint your officers. That's going to be your president, your vice president, your secretary, your treasurer, the boots on the ground folks, the day-to-day operation folks. These are the guys who make the day-to-day decisions. Are we going to buy this? Are we not going to buy this? Are the doors going? What are our hours going to be? All that kind of stuff. Those are the boots on the ground folks. And again, as a small business, single person, maybe two folks, your shareholders, your directors, and your officers, all going to be the same folks. But you've set yourself up to expand and also give yourself some flexibility. Most all of these entities are going to give you, as the shareholder or the membership holder, the liability protection you're looking for. This is not you doing business. This is you separately. You own the entity, but the entity is the one that's actually doing the business. Then you go to, I'm going to start with the partnerships. As I said before, if you're just two folks and you just start doing business together, congratulations, you've created a general partnership under Texas law. You don't file anything, you don't do anything, you just have a general agreement that the two of you are going to do business together and you're going to split the profits and split the expenses, whatever your agreement is. You've created a general partnership under Texas law. You haven't filed anything. Ultimately, you'd have to prove what the terms are, but you've created a general partnership. General partnerships are usually not terribly favorable, and they usually just happen because nobody's paying attention. But if you are going to create a partnership under Texas law, usually what you're going to do is create a limited partnership. A limited partnership has two types of partners. There's a general partner, and there are limited partners. Your limited partners are exactly that. They have limited liability. Limited partners of a partnership are not responsible, liable for anything. They just sit back and receive profits based on their partnership interest. But you also have a general partner, which is basically the face of the partnership. It's responsible for making sure everything happens. It signs all the documents. If the partnership gets sued, the general partner is liable. And again, we don't ever personally want to be liable for anything, so what people usually do is they put a corporation or an LLC as the general partner of their partnership. So now you can see we're starting to get a little more complicated. And the whole point of layering these entities is to shield yourself from liability. Some folks are really, really good at it. They'll have a partnership that's got an LLC as a general partner, and the members of the LLC are two other LLCs who have members who are corporations, and it takes 3 or 4 levels before you get back to any living being. That creates a very unattractive defendant in a lawsuit. Just from what I've seen, this is how it goes. But about 30, 40 years ago, maybe a little bit longer, LLCs became the big thing. They are still the big thing, and probably 95% of all of you out here, or anybody you know, for a small business is going to be the best choice of entity for you because of its ease of organization. It's only got 2 layers. You've got membership, that's who owns the entity, are the members of the LLC. And if you want, you can just have a member-managed LLC. So the members own it, the members manage it, but it's a separate legal entity. That's the easiest way to create an LLC. It's all good. Anybody who becomes a member, who buys in, becomes a shareholder member, they're also a member of the management. They have management authority. If you want to create a second level, Texas law authorizes a manager-managed LLC. So in some cases, clients come to me, they say, we've got one money partner who doesn't really want to do anything, they just want to invest. So they're going to be a member of the LLC because they have to have an ownership interest. But then we got 2 folks who are boots on the ground, they're going to be managing everything. They are also going to be members because they're going to have an ownership interest, but they're going to be the ones managing. So you have kind of 2 levels. You've got your membership, and you've got your managers. So in that situation, you'd create a manager-managed LLC So the two folks who are managing have the authority to manage, but still the member, the money member, has an equity interest, and when money falls out at the end of the day, they get their share, though they're not responsible for any management. Filing fees with the Secretary of State. Each one of these are going to incur a filing fee of roughly $300 to $400 with the Secretary of State. It's a filing fee whether you file with an attorney, LegalZoom, your accountant, anybody. Nobody can avoid those fees. If LegalZoom says, we'll do your LLC for $100 plus filing fees. The filing fees are $300 to $400, depending on which entity. There are things called series LLCs and professional LLCs. If you have a professional license, like an attorney, an accountant, a doctor, something like that, state professional license, you can form what's called a PLLC, which is a professional LLC. There are a few advantages to that from an operational standpoint and also from a tax standpoint. But I think that's beyond the scope of what we're doing here. Series LLCs also get a little more complicated, but in certain situations where there might be a need to create multiple LLCs, the most stereotypical reason for creating an LLC would be real estate holdings. If somebody's a real estate investor, they've got multiple houses, and you don't want, if somebody gets hurt on one house, you don't want them to be able to have access, or if they sue you, you don't want them to have access to the other houses that you own as well. If they're all in the same LLC, that LLC is liable, and all those houses are up for grabs if somebody gets a judgment. Well, what you do in a series LLC is you file one LLC as a series, and every time you buy a new house, you spin off a new series, and it has its own liabilities, its own assets, it's its own entity without a new filing with the Secretary of State and costing you $300 to do it. Without. So you can create what I call the parent series, and then it just spins off as many series as it wants. You can call it 1, 2, 3 Main Street series, 4, 5, 6, Jones Street series. Every time you buy a new piece of property, create a new series, and it is its own separate legal entity. It files its own tax return. It has its own deal, which creates, again, another level of protection from a liability standpoint. Got general partnerships, limited liability companies. Now, to create each one of these, and the names of these documents will be slightly different for which entity you create, but you always have to have a certificate of formation. That is usually a 2 to 4 page document that is filed with the Secretary of State. And basically all it has to state is the name, certificate of formation. I think if you file an LLC, it's called a certificate of formation. If you're filing a corporation, it's called a certificate of incorporation. And if you file a partnership, it's called a certificate of partnership. But each one, they're the same document, they just call them a little bit different things depending on the entity you're filing. That gets filed with the Secretary of State. That's what costs your filing fee. That gives you basically an entity number with the Secretary of State. And if anybody wants to go look to see if your entity is eligible to do business in the state of Texas, they're going to go to the Secretary of State's website and look you up. Have you filed? Are you in compliance with all the requirements of the Secretary of State? Have you paid your franchise taxes? Every year you have to send in what's called a public information report, which annually just says, we're still in business, here's the current management of the entity, we haven't changed our registered agent for service of process, because your registered agent is the person who gets all of the correspondence from the Secretary of State. Anything you need to do, anything you're delinquent, anything the Secretary of State needs to tell you goes to your registered agent. That is also on your certificate of formation. So that certificate of formation gets filed, and that is the bare bones that is absolutely necessary to create a legal entity in the state of Texas. If you do only that, technically you have an entity that you can start doing business under. And if it's only one person, may or may not be all you need. But I would always suggest you have, for a corporation, you have bylaws. For an LLC, you have a company agreement. And for a partnership, you have a partnership agreement. These are the rules, how the entity is going to operate. What happens if you want to bring in another member, shareholder, partner? What are the rules? Who gets to say yes? Who gets to say no? Why can you say no? If the company dissolves, where does the money go? Who gets first say? All these different things, and especially if you're opening a business with someone else, you absolutely have to have one of these governing documents. Because if there are no rules, that I can guarantee you that at some point in time, there might not be litigation, but somebody's going to call my office if you don't have one of those. Because somebody's going to do something they don't like, and if there's no rules, it's a free-for-all. The judge gets to decide what the rules are. We don't want that. So that's usually where people run into problems, because if you go create an entity on LegalZoom, they're going to feed you the standard operating agreement. And by the way, LegalZoom doesn't have an office in Texas, as I understand, and I don't know that they actually have a licensed attorney from Texas on staff. They didn't the last time I checked, and that was about a year ago. So they are creating entity documents for people in Texas, and they don't have a Texas licensed attorney on staff to look over these documents. So, not to pick on LegalZoom or anybody else, I'm just saying it's probably a good idea to at least go talk to somebody. Also, some people will get their entity created by their tax guy, their CPA. And what is their CPA going to do? They're going to file that certificate of formation so that they can get an EIN, an employer's identification number, so that they can file a tax return. That's all your CPA cares about, is they need an entity, they need a number, so that they can file a tax return for the business you're doing. They're probably, in most cases, and I don't mean to pick on CPAs, but 95% of every CPA-created entity does not have anything other than a certificate of formation filed with the Secretary of State. No operating agreement, no bylaws, no meeting minutes, no nothing. They got enough to get the numbers they need. They can file tax returns, and you could probably do business for 15, 20 years, as long as it's just you, and that's all you need. But if you ever want to expand, bring anybody else in, do any sort of significant business with anybody, or borrow money from a bank, that's another thing. A bank is going to want to know that you've got your stuff together, and they're going to want to see all of your corporate docs. And when they say corporate docs, they don't just want your certificate of formation. They're going to ask for your bylaws, your company agreement, any meeting minutes, things of that nature. So when you go ask for a loan, if you do decide to go ask for a loan from a bank or even an investor, if you've got all your corporate docs ready to go, they're going to look at you and say, you apparently have some idea what you're doing, because you've spoken with somebody about this and you've got all the docs that you need. I feel comfortable knowing that you at least have a concept of what you're doing, and if the numbers work, they'll be more likely to approve that loan than if you come to them and say, here's the 3 pages that somebody filed for me, is this enough? And they'll be like, okay, where's the rest of these documents? Because I guarantee you they're going to know what they're looking for. Once you've got all of your corporate documents, you've filed with the Secretary of State. I made reference to meeting minutes. At least annually, the Texas Business Organizations Code does not require it, but at least annually you should have a meeting of the members, managers, shareholders, whatever they are, and create meeting minutes for that meeting and file them with your corporate documents.
It is or not required?
It is not required, but it is best practice. There's no requirement in the Texas Business Organizations Code that you have an annual meeting of any of these entities. And I will tell you, I have reviewed corporate docs. An entity was created in 1985, and they had no records whatsoever of any meetings ever, but everyone who was on the corporate docs in 1985 is either dead or gone from the entity, and there are now 5 new people. But they have no records of how those new people came in, who voted them in, when they came in, what their positions are. They're just, yeah, these are the 5 people we want to have sign the docs. Okay, that's a problem. And so when I'm reviewing documents we represent banks, and when somebody comes in and says, hey, we want $1 million to buy this building, and we say, okay, great, you've got an LLC. You want to buy the building in your name of your LLC? Perfect, give me your corporate docs. And they look at you and go, what? Yeah, here's the 3 pages that my CPA filed with the Secretary of State. Yeah, sure, I want $1 million. And not to make light of it, but that's the problem for most people. Yes, ma'am.
So having a meeting with yourself?
Yes, as ridiculous as that sounds. This year, this is the annual meeting of the member of this LLC. This is what we did this year. We approved all of those things. These are our plans for next year. Here's the budget that we're going to have for next year. Just to have a meeting with yourself. And really, it's not that you need the meeting. It's just so that you have a document showing that every year I've kept track of what has happened this year, and I'm a good record keeper. That's what banks and anybody who wants to do business with you, they want to know that you're a good record keeper. And if you've got all of those meeting minutes, and especially if it's only you, and you say, yeah, I've got meeting minutes for every year that I've been in existence, there you go, you have gone above and beyond. You want to show that. And when somebody says, where's your corporate docs? You need to have a binder that says, these are my corporate docs. It needs to have dividers in it, meeting minutes, company agreement, certificate of formation, so that you can just hand it to somebody and in 10 seconds, they can find exactly what they're looking for. That's going to help you out a lot. And not only help you out with other people, it will help you out so that you know what you're doing. It keeps you on track.
Are those other things that you said, certificate of formation?
Yes. Those are usually the main corporate documents that you need. And the 2 that you really need is the certificate of formation and either company agreement, bylaws, partnership agreement, whatever the rules for the entity that you've created is going to be.
And what was the LLC one?
The LLC is a company agreement.
Okay.
For the corporation, it's bylaws. The partnership, it's a partnership agreement. Now, which one of those entities is best for you is going to depend on your business model, how many people you have, what your plans are, and things of that nature. Yes, ma'am.
Your company agreement and your meeting minutes, are those supposed to be filed with the state?
No, those are held in just held with the company. Yes,
So
ma'am.
can you have employee, like if you're a sole person that like is a DBA or whatever,
Uh-huh.
currently or whatever,
Mhm.
if you decide that you want to do one of those, if you don't do an LLC, like that's still, you don't have to put your employees that you get eventually as members or anything like that.
No,
That is-
no, absolutely not. No, you can just hire folks.
Okay, what if you decide that you do want to share the profits with someone, you want to give them a small stake,
Mhm.
then they would have to be a member, or?
Yes, yes.
Okay.
Because if they do not have a membership interest, then you're paying them a wage. It's a bonus. It's just you've decided this year you're giving them a bonus. But if you want it to actually be a profit share interest, then they would need to be a member. Now, this is also going into tax land as to how that's treated. You could call it, you don't have to give them a membership interest, and at the end of the year, you could say, hey, the company made, $30,000 this year on top of everything else, so I'm going to give you 10% of that, or whatever you decide that's going to be. And just between you and that person, that's what you do. You call it whatever you want to call it from a tax standpoint. But if
But
you want
if you
to,
make them a member with a certain percentage of shares, then does it come out, like, if you decide, okay, we're saving this money, like the profits for something,
Mhm.
does that 10% now, like? they
that would depend on what your company agreement says.
Oh, okay, so you put that in.
So you can make any sort of agreements you want that any distributions of net equity after expenses has to be agreed on unanimously by all members before anything is distributed. You can put that in there. You can put a majority of the members. Or you can say that after expenses are paid, absolutely required at the end of the year, everything must be distributed to the shareholders pro rata on their shareholder interests. You can say whatever you want to say, and you can modify that. In the company agreement, it will say, this is what it takes to modify this agreement. So my company agreements usually are 30 to 40 pages long. Even if it's a husband and wife, they're 30 to 40 pages long. It takes care of what happens if a member gets divorced. So if you got two buddies who are both married, they go into business together, and one of them gets divorced. Well, that membership interest is community property. Well, what happens? Does the wife get it? Do I have a chance to buy out? You put that in the company agreement. What if somebody dies? Their kids inherit their share of the business. Well, you want to address that in your company agreement and give the other shareholders rights if you want to do that. Yes, ma'am.
Question. If you only have one product that you're not actually going to do a business with because it will be too large, you're
Right.
looking to get someone to manufacture and distribute it for you. My product is such that as one individual, I'm not going to be selling it.
Right.
It's going to be. So what are the necessary procedures under that? I mean, it's
Because-
not like they all have businesses
Right.
where they're going to
But because you will be designing a product and you will be responsible for something, you'll enter into contracts with manufacturers, you will enter into contracts with distributors because you got to get somebody to sell this for you. You got to get somebody to make it for you. You've got a lot of contracts that you're going to be dealing with, which every time you sign a legal document, that creates a possibility of liability.
I just want somebody to come and buy it.
Well, if you get somebody to buy it, they're going to write you a check, and I don't care whether you've got an LLC or a corporation or not. But if you are, for any amount of time, if you're going to be, anybody's going to be in any sort of legal agreements with anybody else, you need to create an entity of some sort to shield your personal self from liability. The scariest thing I see is when I've got clients who I had a client walk into my office about 2 months ago. I have 22 rental properties in my own name. Someone could slip and fall on any one of those, or one of those houses could fall down on somebody. Anything could happen in any one of those houses, and all of their personal assets are up for grabs because they own these properties personally.
Well, isn't there some things that are?
There are exempts. There are exempt assets here in the state of Texas. And going through a list of all of what your exempt assets are that people can't take is probably a little bit beyond this, but more or less in most circumstances, no one can take your homestead. If you own your home, no one can take that. Up to a certain limit, your vehicle, personal property in your house, and things of that nature. But if you have any significant assets of any nature, folks are going to take it. If you've got a boat, if you've got a travel trailer, if you've got anything other than one car, a house, and some stuff in your house, it's probably gone if somebody sues you and gets a judgment against you. Then you come talk to me about bankruptcy, which is the next thing that would go hand in hand if you personally get tagged with stuff. That's why we don't want you to come talk to me about that. We want you to come talk to me about entities. So I think as a general concept, I would advise all of you to get an entity of some sort in some way, shape, or form once you get to a point where you are generating, I don't want to say generating profits, where you're generating liabilities. You may not necessarily be generating any profits, but you generate liabilities before you generate profits. And you need to protect yourself from those liabilities. And that's if you get nothing else out of this, it's beware. You're going into business. This is a great thing. Everybody's excited. You're going to make some money. You're going to be doing what you love to do. This is your baby. That's all well and good, but beware. There are plenty of folks out there looking to take it from you or looking to get an easy paycheck. And the bigger and better your business is, the more likely you are to get sued. It is the cost of doing business. I've got plenty of clients out there who are like, all I do is XYZ and I don't make more than $50,000 a year, blah, blah, blah. And these people are suing me and the attorney's fees are going to be more than I make in a year to defend this lawsuit. Sorry, it's the cost of doing business. So you want to do everything you possibly can to protect yourself. And unfortunately, if something goes sideways and you've got an LLC and everything's done properly and compartmentalized in that LLC and you own all your stuff personally, you just say, oh, well, shut down the LLC. I'll have at it. Do whatever y'all want to do on it. And then you, as flippant as I might say it, you go and open a new one. Start doing business over here. Because that person has now, that LLC, has now effectively died. Whatever assets it did have, you can give them to whoever's suing you. Because most entities don't hold a whole lot of assets. And if they do, they're usually inventory or equipment or something like that that's used in their business. And if you want to get really fancy about it, you create another LLC and just lease your equipment to the LLC that actually operates anything. Then that LLC literally has nothing other than a lease agreement with another LLC that actually owns the stuff.
So if someone sues an LLC that doesn't have any assets and they don't have anything to give.
Yep. It's a waste of time. They get a piece of paper that says, that LLC owes you X number of dollars. Go ahead. And if the LLC doesn't have it, they just don't have it. And so that's usually why anytime you borrow money from a bank, enter in a sort of financing agreement, or anything that has anything to do with money with a new small business, they ask you to sign a personal guarantee, which puts you on the hook personally for all of that. And all of this conversation doesn't exist because you now signed a personal guarantee. But what this does protect you from is the lawsuits from folks that you don't have contractual obligations with. Customers that you're selling stuff to. You don't really have a contract with them. If something goes wrong with their product or they don't like something that happened, they're going to sue you. If somebody gets injured on your property at your business, they're going to sue you. Now, obviously, hopefully you will have business insurance, which I would suggest everybody look into, but insurance only covers so much, and ultimately, you need to be protected personally for all of this.
What about like direct sell companies, you know, like the Mary Kay's, the oils, and people like that have their own business,
Mhm.
it's a home-based thing, do they need to have LLCs as well, or is that a different?
I would absolutely suggest, if you're selling lip scents, Mary Kay, anything like that, create an entity. I know the people who own lip scents, Synergents, they have no problem with you registering as an LLC to be your distributor. I don't know about Mary Kay. I don't have any personal knowledge of that one. But yeah, absolutely. If you're doing business, anything more than, you know, you're helping your neighbors out and you get paid for that. If you're doing anything more than that, working with anyone you don't personally know, I would advise having an entity just to protect yourself. The small fee it costs at the front to get it set up properly and to come talk to me, get everything filed, get everything possibly done that you need to have done on the front end, you're under $1,500. And anytime you have a question, you can email me. And you will have a totally custom operating agreement. And through the course of creating that operating agreement, you will ask me 500 questions. I can guarantee you. And we will create an operating agreement or bylaws that are tailored specifically to your entity. And it says exactly what you want it to say. And that's what's going to protect you the most, especially if you're in business with multiple people. Everybody comes in. Things that you didn't even think of were going to be an issue will be addressed in these company agreements. Like I said, what if somebody gets divorced? What if somebody dies? Probably not something that you guys have thought about. What happens to that membership interest? So, like I said, if you leave here with nothing today other than I need to protect myself from liability because there's a bunch of folks out there who are, our society is litigious at this point in time. And if you're going to be doing business, it is part of the cost of doing business to protect yourself from the liability and then defend yourself from any liability that does exist. I would say that you probably need to have a small legal budget in your budget. Maybe a couple $100 a month or, something like that. Just if you need to go talk to an attorney about something comes up, don't be afraid to go talk to somebody because you're in business. You're out with the public. There's plenty of folks out there that want to take things from you because you seem to be prosperous. Whether you are or not, you seem to be prosperous, and people would like to sue people who are prosperous, who seem to be prosperous.
Suppose you're not making any money.
They don't care.
Suppose you just have a product.
Mm-hmm. If you just have a product and you're not selling it to anybody, you're not doing anything with it, there's no reason to create an entity. But if you're going to sell it, you're going to enter contracts to get somebody to manufacture it, you're going to distribute it, something like that, I would advise you to have an entity.
If you have a patent.
If you have a patent, your patent needs, the patent itself, intellectual property, trademarks, patents, copyrights, it's usually best to hold those in an entity of itself that is created specifically for IP purposes. Yeah, for intellectual property purposes, you need an entity that holds that. And any income that comes off of that, any licensing that comes off of that intellectual property would go through that entity separately from any operating entity that may use that intellectual property. Because if the operating entity gets sued, you don't want to lose your intellectual property. So you want it to be in a totally separate entity. This is how you kind of silo different things and keep like things. Usually you create an LLC that is liability heavy. It's the operator. It does all the stuff. Then you come over here and you create an LLC that's asset heavy. It doesn't do anything, so it's got very low liability, and it holds all the stuff that's valuable. And it just leases stuff and lends stuff to the operator that doesn't actually hold anything. So when you're doing business, most of the time, your goal is to create as unattractive a defendant as possible. As unattractive a defendant as possible in a lawsuit. You just want to make yourself look very unattractive to anyone possibly wanting to see you.
So do you recommend pairing LLCs with trusts or having trust?
Oh, going down the trusts road, there are reasons for trusts and there are not reasons for trusts. I think from an estate planning standpoint, trusts are a good idea. From a liability protection standpoint, totally unnecessary. As a general concept, totally unnecessary. Because trusts are taxed differently. They work great for estate planning and for succession planning and moving your money through generations and protecting things for individuals. For business purposes, totally unnecessary. The business entities that we currently have in the Business Organizations Code are much more capable of doing what you need to do for business purposes. Anybody else? Sir?
So your client, the 22 houses?
Yes.
How do you go from owning that individually to moving that into?
You create.
I wouldn't think the LLC would have to purchase the house.
No. You would just transfer it by deed. Title would get transferred into the LLCs. Now, whether that creates a taxable event, I don't know. I don't talk about that. But from a sheer legal standpoint, all you need is a deed that has all the properties listed on it that says, I, the owner of this, just like transferring a house to anybody. You just sign a deed and it transfers the property to them. Same thing for an LLC. You just sign a deed for each one of those properties, transferring the property into its respective LLC.
Would you register that deed or that would just go to your?
The deed is filed with the property records in Denton County, or whatever county the property's in, recorded. It's recorded just like any other, just like when you go to close on a house, when you buy your house, One of those documents is a deed, and it gets recorded with the county property records to show that that deed, that house now belongs to this person. Same thing with an LLC. No, they wouldn't have to buy it if you didn't want to do it. If you call the bank, most banks don't care if you own the entity. That's a due on sale provision in their deed of trust. Most banks don't care. As long as you own the entity, you're the borrower, you own the entity, they're still dealing with the same folks, they don't care.
And it's my understanding that a lot of times banks will lend to an LLC though, so if your property, if you're buying property in an LLC, it's more difficult to get a loan.
Sometimes, yes. Yes, ma'am.
So if you wanted to do layers, stuff where one thing owns all of the
Mhm.
equipment and asset, and one does the actual
Operating, yes.
can you still make it where there's one person that manages everything, makes all the decisions, but possibly has another, member so that with bylaws.
Absolutely.
That has zero power to do absolutely anything and.
But the money just flows out to them.
Well, and when you want it to, you can even say something where, okay, when money flows to this person, money also goes to this person.
Absolutely.
If there's no money flowing to this person,
Absolutely, you can make all those rules.
so you can do whatever.
You can do anything you want. As long as it's not illegal, you can do anything you want.
Question about the intellectual property, so I'm a counselor, so let's say down the line I decide to write a book,
Mhm.
or anyone has a business, I do something else. You were saying the book becomes an LLC, or
No, the LLC owns the copyright on the book.
copyright of.
It owns the intellectual, usually a separate LLC. Now, in your case, I don't see a whole lot of liability there. So your LLC may, or you personally may hang on to that copyright. The copyrights I'm not as concerned about as trademarks and patents. Because copyrights are usually very personal.
And you're available for questions after?
Sure,
the half-hour?
I'll hang out.
Great. Were there any other questions right now?
Do we get a discount for being on meeting?
This is why I have a good daughter. She thinks.
No, we give free consults to anybody who says that they came from.
Years ago,
To anybody what?
Anybody who came from the Center for Women.
How do we
And
reach you, Chris?
I've actually got cards. I've got cards. I'll put my cards right here.
we have become so complicated. Years ago, things were so much simpler. Today, you roll over.
Very good.
All right.
Thank you so much.
Oh, thank you. Thank you.